that the defendant be sentenced under 1244A as a lesser included offense of an attempted smuggling of a person for 120 days in the county jail with credit for all time served. Both counts to run concurrent.
And at this point, I show him with about 108, 109 days of credit. So that might be a time served plea. It's pretty close if it's not. Okay, is that your understanding of the plea agreement, Mr. Lozano?
It is, Your Honor.
Okay, is that also your understanding of the plea agreement, Mr. Chavez?
Sí.
All right, now you understand the plea agreement is not absolutely binding upon me, but should I choose not to follow it, should I choose to be harsher than that, you could withdraw your plea and we could proceed to a trial on this matter at a later date. But if I follow the plea agreement, it is final. You cannot withdraw your plea. You cannot appeal your case without my consent. And this would be a conviction on your record for that attempted charge. And under 1244A, you understand.
Sí.
Now we have in front of us some documents marked State's Exhibit Number 1, the guilty plea and waiver form in this case. It bears the signature of your attorney, the state's attorney, and what appears to be your signature. Did you in fact sign these documents?
Sí.
Did your attorney translate them and explain what they meant to you?
Sí.
Did you understand what he was telling you?
Sí.
Do you have any question about the meaning of the documents?
No, todo está bien.
So if there's never any question, let me briefly explain to you what they mean. Primarily two things. First, you're coming into court and telling me through a judicial confession, yes, Judge, I am pleading to a lesser offense and will be found guilty of a lesser offense of the attempted charge in the indictment. And secondly, you're telling me that you understand that you're giving up some valuable rights here today. The most important of those rights, your right to a trial by jury, not only upon the issue of guilt, not guilt, but also upon the issue of any potential punishment. Do you fully understand that?
Sí.
Understanding that, then how do you plead to this lesser attempted charge, guilty or not guilty?
Culpable.
Are you entering your plea of guilty freely and voluntarily?
Sí, sí, sí.
Did anybody force you, threaten you, coerce you, or in any way make you plead guilty?
No.
Did anybody promise you anything or persuade you in such a manner you felt you had to plead guilty other than the plea agreement stated on the record in open court here this afternoon?
No, nadie.
Okay. Now you understand under 1244A, this punishment range is from 1 day to 1 year in the county jail, a fine not to exceed $4,000. You understand I'll sentence you somewhere within those general guidelines.
Ajá.
Are you a U.S. citizen?
No.
Okay. So then your attorney has explained to you that your plea will result in deportation, exclusion from admission, denial of naturalization under federal law.
Sí.
And let's see. How old are you, sir?
37. Sí.
How old? 6? 37? Okay. How far did you go in school?
Primaria.
In Mexico?
Sí.
You can read and write the Spanish language?
Sí.
Have you ever been under the care of a psychiatrist or psychologist for mental health, mental illness issues?
Una vez sí vinieron, pero pues estoy bien.
Are you presently under any medications for mental health, mental illness issues?
No, no, no.
Have you ever suffered any serious head injuries?
No,
Are you telling me that you are mentally competent, that you understand everything that's going on here this afternoon?
sí,
Counsel, you've had time to go over the facts and circumstances of this case, the legal aspects of the case, and had time to evaluate your client's mental status.
I have, Your Honor.
And based on all that, are you representing to me that you believe he is mentally competent to enter this plea?
I am.
Okay. Then based on your representations, Mr. Lozano, your representations, Mr. Chavez, court's observations of you in court, both here today and previous occasions, I find that you're competent to enter the plea. State may summarize the evidence.
Yes, Your Honor. Had the state of Texas proceeded to trial, the state would have proven beyond a reasonable doubt that on or about the 7th day of November 2022 in the county of El Paso and state of Texas, Jose Alonzo Chavez did then and there knowingly use a motor vehicle to transport an individual, namely Jorge Alejandro Hernandez Joffrey, hereafter styled the complainant, with intent to conceal complainant from a peace officer, and the offense was committed with the intent to obtain a pecuniary benefit. As to count 2 of the indictment, the state would have proven beyond a reasonable doubt that the complainant in count 2 was Sebastian Gomez Gomez. At this time, Your Honor, we'd offer the summary, states 1, the plea papers, the 3914, and the trial court certification of rights.
No objection, Your Honor.
They are received. Based upon the evidence before the court finds the evidence sufficient to defend it guilty of the lesser included offense of attempted smuggling persons pecuniary benefit, and I so find. I'm ready to proceed upon the issue of punishment. Now, Mr. Chavez, once you get released from not only the jail but maybe federal authorities, since I think they have some hold on you, what do you intend to do?
y trabajar, cuidar a mi familia.
You have a family in Mexico?
Sí, mi esposa y mi hijo, mi nieta.
So so you're hoping to return to Mexico, take care of your wife and family.
Sí,
All right. Well, I hope that all works out well for you, and I will follow the recommendation, 120 days to serve in the county jail. And this case will, I'll give you credit for all the time that you have served, and good luck to you, sir.
gracias.
Thank you. Thank you. So let's see, let's do Mr. Gamboa.
Judge, may I be
Oh,
excused?
yes, you are. That's it. That's the only one you had, I think.
Yes, sir. Thank you.
Thank you. And
Your
I think
Honor,
yes.
do you need the interpreter for another case?
Is there any other defendant that needs an interpreter for any of these cases? I'm not hearing anything, so I assume that no one else needs an interpreter. So you would be excused. Thank you.
Thank you, Judge.
Okay, is Ms. Caballero here for Mr. Gamboa?
No. Gamboa.
Remember, you need to leave him the lawyer.
Yes.
We're going for 3 years. Dismissal on the other felony?
Yes.
Okay. All right. So now we're here in cause numbers 2021 0D0 1063 and 2022 0D0 0213, the state of Texas versus Fernando Gamboa. Present in court, represented by his attorney, Ms. Caballero, and the state's attorney there, Ms. Espinosa. Are the parties ready to proceed?
Yes, Your Honor, the state is ready.
Teresa Caballero on behalf of Mr. Gamboa, we're ready.
Okay. Your true and correct name is Fernando Gamboa.
Yes, Your Honor.
Your date of birth, 8/20 of 1974.
Yes, Your Honor.
You recognize your attorney, Ms. Caballero,
Yes.
and Ms. Caballero, you recognize your client, Mr. Gamboa.
Yes, Your Honor.
Okay, Ms. Espinosa, if you would state the plea agreement on the record.
Yes, Your Honor, to the 2021 0D01063 case, the offer is to the lesser included offense of possession of a controlled substance, penalty group 1 between 4 or more than 4 grams, less than 200 grams, and 3 TDC. And I am dismissing 2022 0D0 0213 and as well as 2022 0C0 1734.
And is that your understanding of the plea agreement, Ms. Caballero?
It is, Your Honor.
Is it also your understanding of the plea agreement, Mr. Gamboa?
Yes, Your Honor.
Okay, understanding do you understand that the plea agreement is not absolutely binding upon me, but should I choose not to follow it? Should I choose to be harsher than that, you could withdraw your plea and we could proceed to a trial on these matters at a later date. But if I follow the plea agreement, it is final. You cannot withdraw your plea. You cannot appeal the case without my consent. You would be transferred to the Texas Department of Corrections at their earliest convenience to serve out whatever would remain of this sentence. You do have a substantial number of days, though, already credited. So you understand all of that.
Yes, Your Honor.
Now, we have in front of us some documents marked State's Exhibit number 1, the guilty plea and waiver forms in this case. They bear the signature of your attorney, the state's attorney, and what appears to be your signature. Did you, in fact, sign these documents?
Yes, Your Honor.
Did you read them before you signed them?
Yes, Your Honor.
Did you understand what you were reading and signing?
Yes, Your Honor.
Did your attorney further explain to you the meaning of the documents?
Yes, Your Honor.
Did you understand what she was telling you?
Yes, Your Honor.
Do you have any question about their meaning?
No, no.
So if there's never any question, let me briefly explain to you what they mean. Primarily 2 things. First, you're coming into court telling me through a judicial confession, yes, Judge, I did commit this lesser included offense. And secondly, you're telling me that you understand that you're giving up some valuable rights here today. The most important of those rights, the right to a trial by jury, not only upon the issue of guilt, not guilt, but also upon the issue of any potential punishment. You fully understand that.
Yes, Your Honor.
Understanding that, then how do you plead to that lesser included offense, guilty or not guilty?
Guilty, Your Honor.
Entering your plea of guilty freely and voluntarily?
Yes, Your Honor.
Did anybody force you, threaten you, coerce you, or in any way make you plead guilty?
No, Your Honor.
Anybody promise you anything or persuade you in such a manner you felt you had to plead guilty other than the plea agreement stated on the record in open court here this afternoon?
No, Your Honor.
Now you understand the punishment range for this offense. Is this a 2nd degree felony or 3rd? 2nd?
It's a 2nd, Your Honor, yes.
That's what I thought. Okay, so 2nd degree felony punishment range is not less than 2 years, nor more than 20 years in prison, a fine not to exceed $10,000. You understand I will have to sentence you somewhere within those general guidelines.
Yes, Your Honor.
You are a U.S. citizen?
Yes, Your Honor.
And how old are you, sir?
I'm 48 years old.
And how far did you go in school?
Some college.
And so you can certainly read and write the English language.
Yes, Your Honor.
Have you ever been under the care of a psychiatrist or psychologist for mental health, mental illness issues?
No, Your Honor.
Suffered any serious head injuries?
No, Your Honor.
And are you presently under any medications for mental health, mental illness issues?
No, Your Honor.
And okay, and are you telling me then that you are mentally competent? You understand everything that's going on here this afternoon?
Yes, Your Honor.
Now, counsel, you've had time to go over the facts and circumstances of these cases, the legal aspect of the cases, and had time to evaluate your client's mental status.
Yes, Your Honor.
And based on all that, are you telling me that you believe he is mentally competent to enter this plea?
I am.
Then based on your representations, Ms. Caballero, your representations, Mr. Gamboa, the court's observations of you in court, both here today and prior occasions, find that you're competent to enter the plea. The state may summarize the evidence.
Yes, Your Honor. Had the state proceeded to trial in this case, the state would have proven beyond a reasonable doubt each and every element in the lesser included offense of possession of a controlled substance, penalty group 1, over or equal to 4 grams but less than 200 grams. The state moves to introduce state's exhibits 1 through 2, which are the plea papers and the 3914 disclosure form.
No objection.
Receive. Based on the evidence before the court finds the defendant guilty of the lesser included offense and cause, let's see, that's cause number 1063. And I am ready to proceed upon the issue of punishment. Let's see. Are you married, sir?
No, Your Honor.
Do you have children?
Yes, Your Honor.
How many children?
1,
How old?
12 years old.
How old?
12 years old. Your Honor.
Okay. Are you involved in that child's life?
Yes, Your Honor. She lives in Austin, Texas. She stays with the grandmother of the.
Now, once you get out, what do you plan to do?
I plan to continue working. I started a small business, recycling metal.
Okay. And are you going to have a place to live when you get back out?
Yes, Your Honor.
Where are you going to live, or who with?
I'm gonna stay with my parents until I have a place of my own.
All right. Well, I will follow the plea agreement here in this case. It will be, let's see, you said 3 years to serve. And you will be getting credit for all the time that you have legal credit for.
Your Honor,
And-
could we ask your clerk what that is? He was asking me
Sure.
yesterday. We weren't
Unsure? Well, let's see, what does she show? I showed from a list that was here was it's getting close to 500 days, like 481 or so.
I calculated 651 days.
Oh, you calculated 651?
Yes, Judge.
Okay, well then that's a considerable period of time. So I'll give you the credit for the 651 days.
I think he had been in jail 6 months on a prior arrest.
Yeah, it was the
Well,
same
then
arrest. Yeah,
that's why we gave him credit for that, I guess.
Yes, Judge.
Okay, so you got credit for everything we could legally give you credit for.
Yeah, okay.
And so that's, yeah, you got credit for, yeah, it's not quite 2 years, but you got quite a bit of credit. So, hopefully you won't be there too long. Let's see here. Now, the problem is that you've been down there a couple of times before
Yes, Your Honor.
and not for long sentences. And again, this time not for a long sentence, but at some point you realize that, they could habitualize you,
Yes, Your Honor. I agree.
which would mean that if they convicted you of another offense, you would be looking at like a minimum of 25 years.
I understand that. Sir.
Okay, so, it's time that you don't make these kind of errors again.
I completely agree with you, sir.
All right. Well, some of those offenses were, a while ago, and hopefully it looks like drugs or alcohol have been a problem for you in the past. And if you can, if you get some help, they have some rehabilitation issues in the prison and in the jail system. They also have AA, NA type classes when you get out. You might avail yourself of some of that, and hopefully, just gonna have to stay away from those things.
Yes, Your Honor. I
Okay.
definitely want to utilize any help I can get.
Well, good luck to you, sir, and I will follow the recommendation, 3 years to serve and time credit for all of those 600 and some odd days, and good luck to you, sir.
Thank you.
Thank you, Your Honor. Thank you.
Okay. All right, let's look to Mr. Landavaso then. And there's Mr. Nunez, he's back. Okay. And okay, there were at some point, there were charges 2022 0D0 2942, 2022 0D0 2943, 2022 0D0 4248, and 2022 0D0 3850. And your true and correct name is Angelo Landavaso?
Yes, Your Honor.
Okay, and your date of birth, 2/4/2000?
Correct, sir.
And you recognize your attorney there, Mr. Nunez?
Yes, Your Honor.
And Mr. Nunez, you recognize your client there, Mr. Landavaso?
I do, Judge.
All right, and Ms. Espinosa, if you would state the plea agreement on the record?
Yes, Your Honor, the plea agreement is to the 2022 0D0 2942 case, and that's to the lesser included offense of burglary of a building. And then on the 2943, the lesser included of possession of a controlled substance under 1 gram, which is a state jail offense. And the plea agreement is to 2 years state jail, probated for 5.
So it's 5 years probation then?
Yes, under the state jail offenses, Your Honor.
Right, because they'll be for the lessers, they're state jails. 5, did you say 5 straight or 5 deferred? I'm sorry.
5 straight, Your Honor.
Okay, 5 straight.
And then I'm dismissing 3850 and 4248.
Okay, so it's the dismissal of 4248. And 3850. And is that your understanding of the plea agreement, Mr. Nunez?
Yes, it is, Your Honor.
Is it also your understanding of the plea agreement, Mr. Landavaso?
Yes, Your Honor.
Now, you understand the plea agreement is not absolutely binding upon me, but should I choose not to follow it, should I choose to be harsher than that, you could withdraw your pleas and we could proceed to a trial on these matters at a later date. But if I follow the plea agreement, it is final. You cannot withdraw your pleas. You cannot appeal the cases without my consent. You would begin serving that probation immediately. You understand?
I understand that, sir.
Now, does that take care of all the charges against him, Mr. Nunez?
It does, Judge. And that brings up a good point. I didn't know if, I don't know if he has any, I think he has some misdemeanors lingering, which is a resisting and a criminal trespass. And they stem all from the same incident, Judge. So those are the only 2 that are still lingering around. And
Well, that's what I was trying to
totally
get
my
to.
fault.
In other words, because I'm saying if he's going to be released after the plea, or well, not immediately after the plea, but I mean fairly quickly. And so
Yes, Judge.
either the county courts have to resolve those, or I don't know if they all stem out of the same incident. It's up to the state if they're going to dismiss those misdemeanors.
Your Honor, and just so you're aware, so part of the agreement is for Mr. Landavaso to go to Casa Vida. And unfortunately, there isn't a bed available until March 23rd. But he has placement at the rescue mission. And he, I think, is in agreement to go to the rescue mission until he can go to Casa Vida.
And Mr. Landavaso, are you okay with that, to go to the rescue mission until Casa Vida opens up a spot for you?
So of course, and
Okay.
that is, you do have my address, right, that I'm gonna be residing to as well?
Yeah, the rescue mission. Yes, it's not but a few blocks from here at the courthouse. Of course, you're out at the annex. So there's
Yeah.
got to be a way to transport you from the annex to the rescue mission.
Yes,
And I
So
have
we-
arranged for that, Judge.
What?
I have arranged for that with the resource coordinator out at the annex. So I just need to send her an email, of course, once we get this misdemeanor
Right,
situation.
because
out,
a
and that's-
lot of times in the judgment, it says, release to whoever, the rescue mission people. Yes. Now, I know that the man that heads up that facility very well, Mr. Barrow. And so, do what he tells you and do what they tell you out there, okay?
yes, Your
Until
Honor.
you can get into Casa Vida.
Yes, Your Honor.
Now, the only thing is, what about those misdemeanors, or how are you going to resolve those?
Well, we have at least probably 30 days. I mean, I can get with the misdemeanor ADA and see if they can, I can work out a deal with them. I mean, unless, Mrs. Espinosa, if you want to take a look at them, I know we still have time, so.
Yeah,
I
I'm
mean,
looking, I'm sorry, Judge, go ahead.
yeah, I mean, you can either resolve them by dismissal, or you could resolve them by time served or something like that, I guess.
Right, I'll put a rec in there. I think it might have to be a time served rec on the criminal trespass based on what I'm seeing with the complaining witness, but
Okay.
I'll agree to dismiss the resisting arrest.
Okay,
So I'll email the attorney and I'll CC you.
perfect. Thank you.
All right. Okay, so everybody understand that? Does everybody understand that's the plea agreement? You understand that?
Yeah.
Also then, Mr. Landavaso?
Yes, Your Honor.
Okay. All right. So now we have in front of us some documents marked State's Exhibit 1. The guilty plea and waiver forms in this case, they bear the signature of your attorney, the state's attorney, and what appears to be your signature. Did you in fact sign these documents?
Yes, Your Honor.
Did you read them before you signed them?
Yes, Your Honor.
Did you understand what you were reading and signing?
Yes, sir.
Did your attorney further explain to you the meaning of the documents?
Yes, he did.
Did you understand what he was telling you?
Yes, I did.
Do you have any question about the meaning of the documents?
No, Your Honor.
So that there's never any question, let me briefly explain to you what they mean. Primarily two things. First, you're pleading to some lesser included offenses with your state jail felonies. Burglary of a building, and I believe possession of a controlled substance under 1 gram. And that means you're making a judicial confession. Yes, Judge, I did commit those lesser included offenses. And secondly, you're telling me that you understand you're giving up some valuable rights. Also, the most important of those, the right to a trial by jury, not only upon the issue of guilt, not guilt, but also upon the issue of any potential punishment. You fully understand that.
Yes, Your Honor.
Understanding that, then how do you plead to these charges, these lesser charges, guilty or not guilty?
Guilty.
Enter your pleas of guilty freely and voluntarily.
Voluntarily.
Anybody force you, threaten you, coerce you, or in any way make you plead guilty?
No, Your Honor.
Anybody promise you anything, persuade you in such a manner you felt you had to plead guilty, other than the plea agreement stated on the record in open court here this afternoon?
No, Your Honor.
Now, you understand under a state jail, I've got to send you to not less than 6 months, nor more than 2 years in the state jail. But instead of putting you in the state jail, I can probate your sentence on a straight probation up to 5 years. You understand I have to send you somewhere within those general guidelines.
Yes, Your Honor.
Now, are you a U.S. citizen?
Yes, sir.
How old are you?
23.
20?
23 years old.
23.
Yes, sir.
And how far did you go in school?
I went to a sophomore, but I got my GED.
Okay, so you can certainly read and write the English language.
Yes, Your Honor.
Have you ever been under the care of psychiatrists, psychologists for mental health, mental illness issues?
No, Your Honor.
Suffered any serious head injuries?
No, Your Honor.
And are you presently taking any medications for mental health, mental illness issues?
No, Your Honor.
Are you telling me you are mentally competent? You understand everything that's going on here this afternoon?
Yes, Your Honor.
Now, counsel, you've had time to go over the facts and circumstances of this case, the legal aspects of the case, and had time to evaluate your client's mental status.
Yes, I
Correct?
have, Your Honor.
Based on all that, are you representing to me that you believe he is mentally competent to enter these pleas?
Yes, Your Honor.
Then based on your representations, Mr. Nunez, your representations, Mr. Landavaso, and the court's observations of you in court, both here today and prior occasions, find that you're competent to enter these pleas. The state may summarize the evidence.
Yes, Judge. Had the state proceeded to trial in these cases, the state would have proven beyond a reasonable doubt under case number 2022-0D0-2942, the lesser included offense of burglary of a building, and under 2022-0D0-2943, the lesser included offense of possession of a controlled substance, penalty group 1/1B, under 1 gram. The state moves to introduce states exhibits 1 through 2, which are the plea papers and the 3914 disclosure form in each of these cases.
No objection, Judge.
Receive. Based on the evidence before the court finds the evidence sufficient to find the defendant guilty of a lesser included offenses of burglary of a building and possession of controlled substance under 1 gram, and I so find. I'm ready to now proceed upon the issue of punishment. Now, we've already established where you're going to go. As soon as you can get out, you're going to go to the rescue mission. From the rescue mission, as soon as they have a bed available at Casa Vida, you're going to go there to help get some more treatment. This is treatment in the areas of, drug, alcohol type addiction issues, which have probably been the biggest problem for you. Do you not have, since you're at the rescue mission in Casa Vida, do you have family here in El Paso?
Yes, I wanted to tell you that I have an address. I'm gonna reside here with my grandpa. And it's 5806. No, it's 5608.
So your grandfather says you can go live there
Yes,
after you get out of Casa Vida.
yes.
Right?
Yes.
Okay, very good. And what type of work have you done in the past?
I just worked at a factory when I got out of prison, and I stopped my job. I quit. I got into some issues, but now when I get out, I'm gonna go to Western Tech, or I'm gonna go to Mesilla Valley Tri-Team in the CDL, and I'm just gonna be staying with my grandpa until I can get up on my feet.
So you're going to try to get, did you say a CDL license?
Yes, yes, Your Honor.
Okay, well, that could make, you could make good money doing what, truck driving, I assume?
Yes,
Are you married? Do you have any children?
I have one kid. I'm not married.
But you have one child.
Yeah.
How old is your child?
He's 4.
4. And are you involved in, is it a boy or girl?
It's a boy.
Are you involved at all in his life?
No, not at the moment, and that's the first thing I'm gonna work, all this is for. I'm gonna be working on everything so I can be ready for him.
Okay, well, hopefully you'll be able to support him a little bit financially when you get on your feet, and then, support him emotionally too, and in hoping to raise him and help the mother with him. And hopefully that will work out well for you. So I hope everything goes well. And based on all of that, I will follow the recommendation and 5 years probation on both of those 2 cases. I've dismissed already the other 2 felonies, and I assume they're going to dismiss the 1 misdemeanor, and they will work out the final misdemeanor for you. And good luck to you, sir.
Thank you, Your Honor. Can I ask you one question?
Yes,
So I will be released to the rescue mission. They will transport me there, or they're gonna, or I go.
yes, that's the way it's supposed to work. They release you, and then the rescue mission, once the jail tells the rescue mission he's ready to go, then they will drive out there and they will be ready to pick you up, because it's a long drive from the annex to downtown. They don't expect you to walk all the way down here. And so they will transport you down here to the rescue mission, and then they'll tell you you'll get assigned a bed there and everything. And they do a lot of good work there, and they have some certain jobs for you to do. They've got a lot of good programs, and then when you can get over to the
Casa Vida.
Casa Vida, maybe you'll get some better programs too. So I hope it all works out well for you, sir.
All right, thank
And
you.
Mr. Landavaso, I have to go visit you in the jail anyway, so I will go ahead and clear all that up for you. I already have it, all the details ironed out.
I appreciate you. Thank you.
Yes, sir.
All right. Very good. Thank you.
All right.
Let's-
have a great day.
Thank you. Thank you. Take care. Let's talk to Mr. McCoy next.
And maybe it's dismissed, Judge.
Yes, thank you.
Thank you, Your Honor. Bye, everybody.
Bye-bye.
Bye. Take care.
Mr. McCoy. Okay, this is, good afternoon. This is cause number 2022-0D04661, the state of Texas versus Charles Dean McCoy. Is that your true and correct name, sir?
Yes, sir.
And your date of birth, 4/11 of 1975?
Yes, Your Honor.
And you recognize your attorney there, Mr. Morales?
Yes, I do.
Mr. Morales, you recognize your client, Mr. McCoy?
I do, Judge.
All right. And so, Ms. Espinosa, if you would state the plea agreement here on the record?
Yes, Your Honor, it's to 2 years deferred probation.
Okay. And is that your understanding of the plea agreement, Mr. Morales?
That is my understanding of the plea agreement as well, Judge.
And is that your understanding of the plea agreement, Mr. McCoy?
Yes, sir. Yes.
Now, you understand the plea agreement is not absolutely binding upon me, but should I choose not to follow it? Should I choose to be harsher than that? You could proceed to trial at a later date. But if I follow the plea agreement, it is final. You cannot appeal the case. You cannot withdraw your plea without my consent. You would begin serving that probation immediately. You understand?
Yes, sir.
Now, we have in front of us some documents marked State's Exhibit number 1, the guilty plea and waiver forms on this case. They bear the signature of your attorney, the state's attorney, and what appears to be your signature. Did you in fact sign these documents? And did you read the documents before you signed them?
They were explained.
And did you have them explained to you by your attorney?
The attorney explained.
Did you understand what he was telling you?
He said that I will be on probation if I plead guilty.
I'm having a little trouble understanding you. Maybe, I don't know if you could, I don't know, is he able to remove the mask so we could hear him?
I'm sorry.
Yes, Your Honor.
Okay, go ahead. You did or did not understand what Mr. Morales was telling you about those plea papers and their meaning?
Yes, the two papers were for probation if I pled guilty, but he was talking about I might get off, but I wasn't sure.
I did discuss the possibility of early termination with him, Judge. Yes.
Oh, okay. Yeah, well, everybody can get off probation early, but
Yes,
that's an issue that comes up later. That depends on, you know, it depends on how you do on probation. And this one is a deferred probation, so, you know, I generally look at those issues, and if a person serves about half of the time of probation, then if your probation officer says you're a good candidate to release, I could release you early. But I don't make that decision today. That's based
No,
on
I
your,
understand.
okay, so
It takes about a year and a half.
it'll take a little while. All right. So now you do understand everything that he told you, and you have any question about the meaning of the documents?
No, I don't.
Okay. So if there's never any question, let me briefly explain to you what they mean. They mean primarily two things. First, you're coming into court and you tell me through a judicial confession, yes, Judge, I did commit this offense. And secondly, you're telling me, do you understand that you're giving up some valuable rights here today? The most important of those rights, the right to a trial by jury, not only upon the issue of guilt, not guilt, but also upon the issue of any potential punishment. You fully understand that.
Yes, Your Honor.
Understanding that, how do you plead then to this indictment, guilty or not guilty?
I am plead guilty.
Are you entering your plea of guilty freely and voluntarily?
Yes, Your Honor.
Did anybody force you or threaten you, coerce you, or in any way make you plead guilty?
Judge.
And did anybody promise you anything, persuade you in such a manner you felt you had to plead guilty other than the plea agreement stated on the record in open court?
No, Your Honor.
Now you understand, believe, is this also a state jail felony or is it third degree?
They're both state jail felonies, Judge.
State jail. So not less than 6 months, nor more than 2 years in the state jail. And a fine not to exceed $10,000. But instead of putting you in the state jail, I can place you on probation for any number of years, not less than 2, nor more than 10. You understand I have to sentence you somewhere within those general guidelines.
Yes, Your Honor.
Are you a U.S. citizen?
Yes, I am.
And how old are you, sir?
I'm 40, I'll be 48 this year.
And how far did you go in school?
I graduated, diploma in 94.
And so you can certainly read and write the English language.
I can't write too much, but yes, I can read and write. But I
Okay.
speak Spanish a little.
You speak both Spanish and English. Very
Yes.
good. Okay. Now, have you ever been under the care of a psychiatrist or psychologist for mental health issues?
Yes, I am.
Okay. And what has been the issue?
Manic depression, bipolar with panic attacks, and I have sleep apnea.
Okay. Now, are you presently getting medications for that?
Yes, I do get it in the jail, but it's jail received. I can take them or I can go to my psychiatrist or doctor.
Okay. Are those medications helping you?
Yes, they have been.
Okay. Are they helping you to such a degree that you think you are mentally competent? You understand everything that's going on here today?
Yes, Your Honor.
Okay. So it's really important that you stay on your meds.
Yes,
Okay.
yes, Judge.
Now, counsel, you've had time to go over the facts and circumstances of the case, the legal aspects of the case, and had time to evaluate your client's mental status. Is that correct?
That is correct, Judge.
Okay. And based on all of that, are you telling me you believe he is mentally competent to enter this plea?
I do believe he's mentally competent to enter a plea today, Judge.
Then based on your representations, Mr. Morales, your representation, Mr. McCoy, the court's observations of you in court both here today and prior occasions, find that you are mentally competent. The state may summarize the evidence.
Yes, sir.
Yes, Your Honor, had the state proceeded to trial in this case, the state would have proven beyond a reasonable doubt each and every element in the offenses of credit card or debit card abuse and fraudulent use or possession of identifying information. As alleged in the indictment, the state moves to introduce state's exhibits 1 through 2, which are the plea papers and the 3914 disclosure form.
No objection to their introduction, Judge.
Receive. Based on the evidence before the court finds the evidence sufficient to find you guilty, but I am not finding you guilty because this is a deferred plea. And again, I will wait until some later date to finally adjudicate or decide your case. If you do well on probation, you do everything you're supposed to do, you report faithfully, you don't commit other offenses, then I could eventually dismiss this case against you and would be no finding of guilt. And hopefully that would be of some help to you in regards to job opportunities and things like that.
I
But if
do
you,
have plenty of job opportunities, and I thank you, Your Honor, taking the time to give me help this year. I appreciate you taking the time to let me go on probation. I'd
oh,
like to say that I was trying to get to the court-appointed probation 9-month facility down here by the airport. I wanted to go to Liviani, and Liviani detox también, and I was trying to go to the hospital, but if I don't need it, I'm okay.
all right. Well, what I'm going to do then is now the question is that's most important here is now where are you going to reside when you get out? Do you know where you're going to go?
I do want to go to the Opportunity Center, but then I do want to stay at the mission, state mission. But I have been in contact with the child abuse and molestation, family violence, and children that have been there. I'm trying to go back there right now. It's just I had to get all the paperwork. I didn't know all that was happening. So I know I can be accepted there, but at the same time, I probably have to live at the mission or at the mission or at the Opportunity Center.
Okay, Mr.
Judge,
Morales, have you all made arrangements to get him transported?
What I'll say, Judge, is the last time we were in court actually in person, I guess it was last Friday, Mr. McCoy was also interested. He mentioned going back to Albuquerque, New Mexico, because I guess he's legally married to a woman in Albuquerque. So we're gonna talk to the court about maybe going back to Albuquerque if that was possible, Judge. But I guess it's up to Mr. McCoy where he thinks he can be most successful and where the court would like him to reside.
Well, yes. Now, at first, when he gets out, he's going to have to go either here, like you said, either to the Opportunity Center or to the rescue mission when he starts out. Now, if you want us to transfer your probation to New Mexico and go live in Albuquerque, because I understand at one point you were trying to get on the bus to go
Yes, sir.
somewhere else, but not Albuquerque. But anyway, if you want to reside there, then make sure your probation officer tell her or him
Yes, sir.
that you have family, and then they'll try to see if they can transfer your probation to New Mexico. But
No
if you
problem.
want to stay, but if you want to stay here, well, then just stay here and report here. Okay.
Yes, sir, I can do that.
All
I
right.
don't mind staying here at all, but I
Okay.
do have family and stuff in Albuquerque.
All right.
I'll
Well-
take care of that when I get to it.
Okay. Well, stay in close contact with your
Sure.
probation officer.
And will
And
I
then,
be
and
recording?
then secondly, they can get you to good treatment also. And then most important, stay on your medications.
I will. Swear.
And Judge, just a note for Mr. McCoy, do not leave for Albuquerque without the court's permission. Don't do that.
Yes, sir.
Okay. Well, then I will follow the recommendation, 2 years probation deferred, and good luck to you, sir.
Christian, thank you, Your Honor, and Judge. God bless
Thank-
you.
Thank you. Take care. Okay, let us talk to I think that is the end of the pleas. Is that correct? Because we had reset the Mr. Doolittle plea for another day. Right?
That's correct, Judge.
Okay, so we will talk next to Mr. Eric Gomez.
Coming right out, sir.
Okay, now this is a bond hearing.
Just a second.
Woman, sir.
Just a second, man. Okay, Your Honor, this.
Okay, so this is cause number 2021-020-1846, the state of Texas versus Eric Gomez. The charge, aggravated robbery. What is that? 6 counts. And the defendant has been in jail, I believe, about 611 days. What is the bond on the case? The amount of bond
500,000.
is a combined bond of 500,000. Is that correct, from the clerk?
We're on Eric Gomez.
Yes.
No, I have a split bond, which is 100,000 surety and 250,000 PR.
100,000 cash surety and 250,000 PR.
Yes, Judge.
That's what it is presently combined on all the counts.
What do they change it? I've got, okay.
I don't know. Okay, we did a bond hearing once before in September of 2021. At that point, it was 500,000.
Yeah, that's what,
And what happened was I then later in September 23rd, after discussing all of this, I then set the bond at looks like 250,000 cash surety 250,000 PR. But I don't know, I don't see it reduced again below that.
Neither do I, Judge. I don't see it reduced below the 500,000.
Yeah, we've gone over the facts of the case. The wreck in the case is what, Ms. Espinosa?
Judge, I don't think I have a recommendation.
Oh, okay, because I saw a
Actually-
10 TDC wreck.
There was
Yeah, I
a 10
have-
TDC rec and it
That's-
was pulled.
Okay, so they
Because it
was
is-
10 TDC at one time.
That was Curtis Cox's rec. But I believe I told defense that it would be more if we did recommend something, it would be. And either way, I think defense said that they're not going to accept any TDC recs, so we pulled the rec.
Okay.
It's going to be TDC, but I basically defense made it seem like they're not going to take anything having to do with TDC.
Okay. Do we have a trial date?
I don't know, Judge. I don't have anything.
Yes, Your Honor. Well,
What's the trial?
it seems like we have one for June 12th.
Okay, June 12th of this year. Because I am anxious to try this case, obviously, if we have to.
That's correct. Judge.
Um, there were some fairly aggravated facts alleged in one of the counts anyway. Did you want to go over any of the facts of the case with me that you want to point out, Ms. Espinosa or Mr. Aboud? First, Ms. Espinosa.
Do you want me to go through all of the facts, Judge, or
No,
just?
just whatever facts that you think are pertinent to this bond.
Well, Judge, I mean, I understand that, maybe the defendant doesn't have any criminal history, or serious criminal history. However, one of the complaining witnesses, one of the people involved in the incident, suffered severe injuries, including traumatic brain injury, has memory loss. To this day, he can't walk. He requires the assistance of a walker. He can't work anymore. He's completely disabled. He used to work at a mechanic shop. I think it was for one of the local dealerships, and he can't do that anymore. He used to, I think he was not a coach, but I think he was a coach actually for a minor league team, and he can't do that either. His wife says that he suffers from depression, and he's not the same person anymore. His personality has even changed. And so these are very, very serious injuries. And the allegation is that this defendant was the driver at the time. And I'm not sure exactly what happened between himself and the co-defendant. However, it's clear that he was driving recklessly and caused this accident. And so we would ask, we would ask for no reduction, Your Honor, but obviously we are set for trial soon, and we will be ready to go.
Was something about running some red lights or something, finally colliding with a vehicle. That must be the one you're talking about.
Yes, going on 54,
Yes, and
and
somebody.
then finally
yes, I've got
exiting and
notes where
colliding. Yes.
There was an individual who was very seriously injured. Let's see.
They collided into several and caused an accident between several vehicles. There are about 5 individuals.
And now I did hear at the last bond hearing. Yeah, I did hear the severe brain injury that was involved. Defendant has always helped with the family. I think his mother was a cancer survivor. many family members in Canutillo. Family also, parents live in Chaparral. I think the father testified at the last hearing even. Okay. Are there any additional facts other than the fact that at the time of the last bond hearing, he had been in jail 86 days, and now, of course, he's been in jail a much longer period of time than that. He obviously cannot make that bond. It's beyond that of himself or his family to post it. Is there anything else what do you want to bring to the court's attention, Mr. Abood?
Your Honor, I believe it was obvious they were drinking beforehand, but the driver, the owner of the car just got belligerent and just really intoxicated and went off on some kind of mental spree, and they were racing all the way up to Northeast El Paso. And that's when my client got in the driver's seat because he didn't want to be with the man anymore. And they were actually fighting when he was trying to drive off in the car. And he didn't go into the store, or I don't know what it was, a smoke and liquor store. It was a co-defendant, and they started punching or fighting in the car, and that's what caused him to go into the accident he had. He has a very minor prior record with no convictions, lifelong resident, U.S. citizen. I'm asking for maybe a $10,000 cash or corporate surety bond with the rest in PR bond.
Ms. Espinosa, your recommendation?
Your Honor, again, we would oppose any reduction, considering that the recommendation is it's gonna be TDC time. And we feel that that would make him a flight risk.
Okay. Well, the motion for reduction of the bond is denied, but we are going to go to trial on the 12th of June. We need to try this case. Both the defendant and the complainant need a trial, and we got to get going. Defendant has been incarcerated for an extended period of time, and I want to make sure he gets his day in court. And I remember these facts. It is a very complicated between the two co-defendants. There's discussion and argument between them as to who is more culpable or who is really culpable in this case. And I don't know where we have to work that out. Did the other co-defendant's case get resolved yet? I don't think so.
No, Judge, that's also set, and it's set for, it looks like it might be set sooner, May 16th.
Okay. And is that defendant in jail?
I can check. Yes, he's still in jail.
And it looks like the allegation here is that what you had was kind of one of the defendants went into the smoke shop, took something kind of like a shoplifting or something, and then they run out, they get in the car, and then that's when the car leaves, and that's when there is some discussion about fighting over the steering wheel and who's trying to stop who, and who's trying to drive recklessly versus who isn't. And I think there's some videos here. I don't know if they were. We have some videos. I think we've even seen them. They were shown to the court as part of the bond hearing at one time before you were the attorney, Mr. Abood. I'm sure you've seen those videos by now.
Not yet.
Okay.
They
Well,
been provided to me.
Well, they should be up there. I'm sure they're there. And so that's an important piece of evidence. Let's get ready for trial in June. And of course, you may see something happen in the trial in May. If the other co-defendant goes first, that may give you some indication of what's going on.
Okay, Judge.
All right. Thank you.
Thank you.
All right. Let's proceed on with the next bond hearing on Mr. That would be Jesus Jose Chavez. That one is again, that's with Mr. Morales.
That is correct, Judge.
Okay.
Have a good day, Your Honor.
Okay. Okay, this is cause 2022-0D03400. And let's see, the defendant has been in jail.
About 50 days, something like that, Judge.
That looks right. I got 48, maybe somewhere in there. So it's been in, let's say, 2,
That's my understanding as well, Judge.
23, 23, bond hearing. And what's the bond presently set at? Is it like,
What do I have, Judge? I'm
oh,
showing
50,
the
probably
bond.
about 50,000, I think.
That's correct, Judge.
Judge, I had 5,000. Does that?
No, it's
50,000?
50,000. And the reason is, wait, days, is because, let me get to that. The defendant was out on bond. This was basically a shoplifting type case. He's got somewhat of a, he's got a little bit of a, got some record there. But he was out on a bond. I think maybe they put him out on a PR bond at one point. And he failed to report. Is since November 2nd of 2022. They reported that to me on December 19th of 2022. And when you stop reporting on a PR bond, I revoke a PR bond automatically. And then I usually set a higher bond to determine why they stopped reporting. And so now, if you want to explain to me, Mr. Morales, why I should, what kind of bond can Mr. Chavez make?
And Judge, we'd be asking the court for a full PR bond. Mr. Chavez has been appointed to the El Paso County Public Defender's Office based on his indigent status. You are right, Judge. There is some history there, but I think that Mr. Chavez has kind of turned a corner here. He is one of my rare clients. It's actually got a couple of years on me. He's older than I am here, Judge, and you were correct that this is a theft case, Judge. I mean, he was, and I'm sure Ms. Espinosa will correct me if I'm wrong, but I believe that he was stealing food from a Sam's Club out in East El Paso. Another one of these instances where I just got to think that there's a better solution to other than incarceration for Mr. Chavez. And I'm certain that if we get him, if we're given another opportunity to have him out on a PR bond, I know that he would treat it with the requisite amount of seriousness and he would make.
Well, that's what I've got to be convinced on. I mean, why, if I put him on a PR bond once and I didn't put him on the PR bond, the other people did. But if they put him on a PR bond once, what is there now in his history that's going to tell me that he's going to report on to PR this time if he didn't want to do it the last time?
And Judge, I think what happens is they don't always have all the tools. I think maybe it was a communication problem for Mr. Chavez here. I'm looking through my notes. I think I'd even spoken to him about this specifically on this point. Give me just a moment, Judge. Let's see. He's originally from here in El Paso, Judge. So I think he would stay here in El Paso. The case that that he picked up was here in El Paso, Judge. If you're wondering whether or not he's going to report, I just think that the court is certainly got his attention here in the last 45, 50 days or so that he's been locked up. And I'm highly confident that Mr. Chavez is going to make every effort, because it doesn't take a lot of effort. You're absolutely right, Judge. And he's going to make sure that keeps a phone, either keeps a phone, and if he can't keep a cell phone, then he's going to make his way on down there in person to report under any circumstances that the court lays out for him, Judge. I think he knows that he made a mistake here, and not only the mistake in the initial case, but not maintaining the contact with the PR bond office, Judge. I just think that this 45 days, we got his attention, and he's going to stay with it, Judge.
Okay. Let's see, as I look at the criminal history, it looks like in 1991, if I'm not correct, am I right here, Ms. Espinosa? It looks like a burglary of habitation. He did, was it 2 years TDC?
No, Your Honor,
21.
I'm pretty sure for some reason it says 21 years.
I've got 21. I was looking at that, I said, that's gotta be awfully high.
I have
21
21 as well, Judge. I
21
think that-
TDC, because he got revoked.
I think
And
it was
then-
Judge Paxton on that
And it
one.
was 1992, a burglary of building. He got 15. I guess those things ran concurrent.
Right, and I think it's because it was more than one burglary of habitation, Judge. It was 2 different charges.
Mhm.
And then there
And
was
then
a
you got-
burglary of building.
And then he got out, and then in 2001, he got another burglary of a habitation where he got 9 years in prison. So back, let's say 20 years ago, he got in a lot of real serious trouble. He got, in terms of real serious trouble, I mean, he served a lot of real serious time. Two prior convictions, which could have habitualized him. But since then, I don't see a lot of real heavy offenses. I see an assault for 30 days in the county jail in 2013. I see a theft in 2016 for 10 days.
A lot of theft, Judge. I mean, it kind of reads like the record of someone who maybe
But I-
did not get the benefit of the doubt 30 years ago or 35 years
Yeah,
ago.
I don't think I don't want to hold that record that much against him. What was the rec on this case? And apparently the state didn't either. They did not make a rec like that was going to be like a, 25 TDC or something.
And Judge,
They
I
made-
appreciate you not holding against them, but what I would say is, this is what happens, right? I mean, if you put someone in prison for that long a period of time when they're that young, you mentioned it, Judge, this is not the first theft that he's been charged with. Mr. Chavez is always playing catch up, Judge. I mean, I won't diminish the cases that he's picked up recently, but they are thefts. And this time he is stealing food, and that 21, 30, 35 years ago, it's meant that he's been playing catch up his whole life, Judge. And I think he's tired of running, even though there is an allegation of evading arrest on this one on foot. I think at 57, going on 57 years old, or catch me if my math is off there, Mr. Chavez, but I think he's coming up on 56, 57 years old. I was hoping for a time served in terms of a recommendation.
I don't know what they're,
substantially higher than that, Judge. Ms.
but I mean,
Espinosa.
if you're looking to, well, I think where were you at? You were at a 2-year state jail?
Yes, Your Honor, and I think the last time we were here, Michelle Hill also recommended that.
And of course, Judge, he did get the theft cases are misdemeanors, and it's the previous thefts that bumps them up to a state jail. And I think the state could probably even enhance it even further, but I think that just continues an injustice that was played out on Mr. Chavez 35 years ago, Judge. I mean, the man is just constantly trying to play catch up here, and it just seems harsh, 2 years for stealing food. I'd love to get him out on a PR bond, get him in here in the office, sit down, watch these videotapes, talk to him and figure out more about his story. And maybe there's something in there that we could use as mitigation that would be compelling, that would be persuasive for Ms. Espinosa, Judge. That's what we're hoping for, is a full PR bond on this one, Judge. I think there was actually a PR bond that was granted maybe on the misdemeanor as well already. I think this might be the only thing that's holding him, Judge.
I'm sure it is.
So, and I'm sorry, Your Honor, what was the reason that he stopped reporting, Mr. Morales?
And Mr. Chavez would have to clue us in, but I think it was a phone issue on this one, if I remember correctly, Mr. Chavez. Because I think there was no in-person reporting when he started off, and that maybe it was just a maybe not even having a phone. I'm not sure, but I'm just kind of glancing at my notes from before.
Okay,
But-
but
Well, he did report for a while, must have.
I believe so, Judge.
and is Mr. Chavez aware now that he has to report to PR?
Mr. Chavez, yeah, Mr. Chavez, what, why, what can you say that would convince me, if you wish to speak, that would convince me that you would really report this time?
Well, I can guarantee you that I will. I can surely guarantee you that I will. Even if I have to report on person or however I gotta do it, but I'll be reporting.
Where would you live? Where would you?
I'm living at 9819 Norton through a program that I'm in through Emergence Network. Yeah, they got me an apartment, so I have an apartment right now. That the thing that caused me not to report is that I lost my phone, and then I had some families coming from the holidays, but from August to November, I was reporting just like they told me. And when the holidays came in, some stuff came up and I lost my phone, and I forgot. I kind of forgot, and it was just, I got wrapped up with my family coming out of the States, to El Paso, and that was the reason I started.
Is your family here?
No, my family's in California. But August, September, and October, and probably the beginning of November, I was reporting like they told me.
Well, let me take this one under advisement until tomorrow, and I'll see both you, Mr. Morales, and I'll see you, Ms. Espinosa, tomorrow, because we got a lot of hearings tomorrow.
Understood, Judge.
And I'll make a decision by tomorrow.
Thank you very much, Judge.
All
Thank
right. Thank you. Okay. I guess the last one is Mr. Velman.
Good afternoon, Judge.
Good afternoon, Mr. Montoya.
And actually, there's going to be a correction to my client's name.
There's going to be a change. What?
Client's name.
Oh, okay.
Actually, here's the funny thing. It doesn't need to be a true name change because they got it right in the indictment. In the indictment, his name reads Alfredo Trinidad Andrade, and that's correct. Just somewhere along the way in the system, they put the name as Belman, but if you look at the indictment, it's correct. It's Alfredo Trinidad Andrade.
Okay. All right. And there's Mr. Andrade then. And this is a bond hearing. And I don't believe I've had any hearings on this case up to this date.
No, Your Honor, I just, while waiting my turn in line, I emailed to Michelle the waiver of arraignment. So
he's got 113 days in jail. And what is the bond presently set at?
$20,000, Your Honor, 19,000, cash corporate surety, 1,000 PR.
So we got 19,000 cash surety, 1,000 PR. All right. So, Ms. Espinosa, if you want to give me the facts of this case alleged from your standpoint.
Yes, Your Honor. And so in this allegedly occurred January 1st of 2022. Police were dispatched to a rollover
Of
accident.
2022?
Yes, Judge.
2023. Okay, so it's over a year ago. Okay.
Correct. I
Okay.
believe it was January. Let me make sure. Give me 1 second, Judge. I want to be, yeah. Oh, I'm sorry. No, I think it was November 1st of 2022. I apologize.
November 1st,
Yes.
2022. Rollover accident. Got it.
This was off of 54 near exit 27, which is by Hercules. And basically what happened is the defendant was driving a 2003 Hyundai Sonata going south on 54 by the Hondo Pass entrance ramp and rear-ended the complaining witness, which was a 2002 Toyota Tacoma, which then rolled over multiple times. And the complaining witness suffered 2 broken ribs. The defendant sped away on 54. I think so. One of the witnesses actually had the accident on video from her vehicle. And there was another witness that saw him flee. And another witness saw him pull over with his hood smashed in. He pulled over to fix it, I guess to close it down, and then drove off and pulled into a Chevron on Dyer. And another officer saw the defendant at the Chevron on Dyer and called the officer at the scene of the accident to say that he was, the suspect was there. He had bought a 24-ounce Modelo.
When he pulled into the Chevron, he buys?
Yeah, he got off and he bought a 24-ounce Modelo, and he was approached by police as he was going back to his car, but he wasn't in his vehicle at the time.
Okay.
And I don't think this was a formal statement, but he allegedly told police at the time that someone had stolen his car and he was traveling by bus. When police told him that they had a witness placing him at the scene of the accident, he changed his story and said that, yeah, he had hit the pickup truck, but he left because he didn't have a driver's license or insurance.
Did they say he was intoxicated there at the station? I mean, at the gas station?
No, Judge, I think they
'Cause
tried
it says intoxication assault. Did
They
do
tried to
blood
do
alcohol?
SFSTs, but he refused.
Okay. Did they do blood alcohol or something at some point? Because
Yeah, let me check.
you're
Judge.
alleging intoxication.
We don't have I don't think we have the labs. Let me check.
We didn't do a breath.
Yeah, we don't have. There has to be something from the. Oh, okay. No, there was, he did subsequently provide a breath sample, resulted in 0.213 and 0.213.
Okay. What's his criminal history?
So according to the rap sheet, Judge.
Are there other DWIs?
Yes. So there here in El Paso locally in 1987, there was a DWI that was dismissed. But according to the rap sheet, there was in 2001, there was a vehicular homicide, DUI in Colorado, Liquid, Colorado, that was also dismissed. And then in 2000,
When?
I'm sorry, Judge?
When was that one?
That was 2001.
2001? A vehicular homicide?
That's what it was listed as, yes.
But
And
it was
then
dismissed.
yeah, it was dismissed. And then 2002, a DUI in Colorado, 1 year jail.
How much time? 6 months, did you say?
1 year.
1 year on a DUI?
Yes.
And is that it?
That's it. That's all I saw, Judge. Yeah.
Okay, Mr. Montoya, about your client. Is
Uh,
he from here? Or-
Yes, sir. He was born in El Paso, Texas. He is a United States citizen by birth. He, upon release, would be trying to seek a job in the food service sector. He used to work in construction, but his back was injured at some point, and so he can't work in that area anymore. And that's why he wants to work in food service. My client's residence would be here in El Paso County on Paula Court, where he would be residing with his mother, Maria Andrade, who has frequently been in touch with my office, Your Honor. My client is prepared to comply with any combination of conditions which the court may impose as a condition of his release. And we're asking Judge for full PR bond, or as close as possible that the court can get to a full PR bond. My client-
he's not married?
No, I believe he's not married.
Does he have children?
You know what? I forgot to ask him that. Mr. Andrade, do you have children?
No, sir.
No children, and you're not married?
No, sir.
Okay.
Okay. So you want a PR bond or almost completely PR bond because he has very limited ability to make bond.
Correct, Your Honor. I'm
And
appointed to
Ms.
represent him. He has been bound and deemed.
Ms. Espinosa, your recommendation is?
I don't have a recommendation on the case yet, Judge. But we would, we would oppose a reduction on the basis that this is a pretty egregious charge. We feel like he would be a flight risk, especially if he has criminal history in Colorado. He might end up fleeing back to Colorado. And no significant family ties except for his mom, it seems like.
All right. All right. I'm going to deny. I think the bond is what, 19,000 cash, 31,000 PR. Yeah, I don't think it is excessive. For the type of an offense. And there was the flight here from the initial scene. And now I can't, does your facts tell me that was he drinking that 24-ounce beer, or was it still closed when they went over to, or can you know?
It doesn't say, it just says that he walked in and purchased it.
Because I mean, it would be very disturbing to me if you were at 0.213 and you hit somebody, caused them to roll over, went down to a gas station and decided to buy more beer. That, that's a rather disturbing fact, if that's the way it happened. Now, I mean, or was he sober, hit the car, rolled over, went down and then drank a beer, and went to, I don't know, one beer, can get you 0.213 that quickly, but I mean, I don't know. It seems more like the first possibility more than the second. But
well, yes, Judge, and I'm sorry, I neglected to give you more information. It just says that when they spoke with him, he also mentioned that he hadn't slept for 3 days, that when he drinks, he does not sleep. And he said he had drank vodka and a 24-ounce can of Modelo. I guess I don't know if that was prior to or not. And then they just said that when they encountered him, he had the alcohol beverage inside of a paper bag. But yeah,
Okay.
they couldn't, it doesn't say whether he was drinking at the time of being approached.
All right. Well, I'm going to deny the bond reduction. And is it set for a trial?
Yes, sir. We're set in January of 2024.
January?
January
Not it.
22, 2024.
Okay. All right. Well, I think we maybe should try to do a little better than January, but we'll see what we can do. All right. Thank you.
Thank you, Your Honor.
Okay. Is that all of the cases then? I think that concludes all of our hearings this afternoon.